Hello everybody, my name is Mark Halsey. I'm with Fiona Halsey and we are Halsey Legal. During a recent presentation we provided, we spoke about ASIC notices and the topic of legal professional privilege was raised. So we thought we'd do a presentation on legal professional privilege. Let's kick it off by asking Fiona, what is legal professional privilege?
Legal professional privilege is a privilege that applies in respect of advice that a client receives from a lawyer, or alternatively in respect of documents which are brought into existence or created for the dominant purpose of contemplated or actual litigation.
Okay, so you mentioned litigation. What exactly do we mean by litigation? How broad is it?
It's a very broad category. It would apply, for example, to litigation between individuals and companies. It would apply in relation to a proceeding brought by a regulatory authority, such as, for example, ASIC.
Mm-hmm.
It would apply in even somewhere like AFCA respects legal professional privilege. The privilege, and it's important to realise that the privilege is a privilege which actually belongs to the client. And what it effectively does is allows the client not to disclose that communication or document, whatever it is, in the proceedings where it would otherwise have to be disclosed.
Terrific. So when does legal professional privilege apply?
It applies to the two circumstances which are the fundamental one of when you've obtained legal advice, mm-hmm. or alternatively if it's been created for the dominant purpose. Mm-hmm. But it only applies to the extent that it is kept confidential.
Okay.
So if you've disclosed it to other people, then it's referred to as waiving privilege. Mm-hmm. So you can give up privilege on a document which you might very much want to protect.
Or lose privilege, in fact, as opposed to consciously.
Totally.
Yeah, okay. Now, you've talked about documents having to be created for a particular purpose. What if, with the benefit of hindsight, you look at a document and you think, oh, that would be handy, but I don't want anyone else to see that. Can you backdate or retrospectively claim privilege over a document?
No. It's for what you're talking about there is you're talking about the litigation privilege, because that would be a circumstance where, for example, you might have, say you had acquired a report, mm-hmm. And that would be something that financial services people would see quite often, mm-hmm. would be that they have had a report created of some kind. Yep. If that document was not created for the dominant purpose of actual or contemplated litigation, then the privilege does not apply.
And you can't backdate it? You
can't.
Okay.
What is interesting is you can have different versions of a document. Mm-hmm. So, for example, if you'd had a report and then there were changes made to that report by the solicitor who was, for example, undertaking advice in respect of it, then the comments by the solicitor on that report themselves might be privileged, mm-hmm. but it doesn't change the original report. Mm-hmm. And that's something we see quite often in practice, is that reports undertaken, for example, of client files at a time when it wasn't contemplated for litigation they're technically available through the discovery process.
Okay. Now, it's obviously a very valuable right, legal professional privilege, and one where you would look in terms of creating a document for the purpose of getting that privilege. Can you do anything to lose that privilege?
Yes, you can disclose it to someone else. So, for example, you might, and the classic one where people do it, mm-hmm. is that they actually say to the other side, they say, I have legal advice that says that's not the case. Well, once you've done that, okay, you have disclosed the nature of the advice, and it's very likely that you will have lost privilege over that advice.
So you'd have to show the other side your advice?
Potentially.
After paying for it?
That's right. And it's that's particularly bad because it's quite common that when you get a lawyer's advice, mm-hmm. it quite often says, on the one hand and on the other hand. So it might say that the better view is the view you're taking, but it might very well set out an extremely useful argument for the other side. And the other thing is that you often have provided the solicitor, giving the advice, with quite a lot of information. Mm. And most solicitors will include that information in their letter of advice,
sure.
Which would be information which the other side might not have.
Mm.
So very nice to get.
Pretty lethal.
Totally.
Yeah.
You'd want to be very careful not to disclose that advice.
Okay, so that's the idea of confidentiality. Are there any other restrictions in terms of legal professional privilege?
Yes, it does not apply to a document created for an improper or illegal purpose.
Mm-hmm.
So, if, for example, if you were to see if you were to consult your solicitor and say, I want to carry out a bank robbery, how do I do it?
Yep.
It's an extreme example.
Yep.
The advice from your solicitor in respect of that, if there was such advice, would not be privileged because it's for the furtherance of an illegal purpose.
Right.
And in 2017, there was a decision by the Federal Court in the case of Allcare Dairy and Huang. And in that case, the court looked at the fact that the party had engaged in fraudulent conduct, mm-hmm. and it had obtained advice from its solicitors to assist in that.
Mm-hmm. The
interesting thing is the solicitors in that case had no idea that these people were planning the fraudulent conduct, okay? But the advice was still not privileged because of the underlying purpose that they had wanted to do something illegal with the activities.
Right. So this legal professional privilege discussion also relates to, or hangs off the previous discussion about ASIC notices. During the ASIC notices, you were referring to the claiming of privilege during an ASIC Section 19 interview. Is that legal professional privilege?
Generally not. It would be if ASIC was to issue a notice to you to provide a particular document, then you might say, no, I'm not providing that because it's subject to legal professional privilege. Mm-hmm. But the privilege you're most likely to be claiming in a Section 19 examination, which as we've discussed previously is actually an interview, is likely to be the privilege against self-incrimination.
Right.
And that's an important privilege, which is one of the cornerstones of Australian law, because particularly in a circumstance such as a Section 19 interview where you're not permitted to not answer a question. So in that circumstance, you are claiming privilege against self-incrimination, mm-hmm. so that the information that you provide against yourself can't be used in some proceedings. Okay.
What's the interaction between legal professional privilege and privacy laws?
Yes, people often, particularly if you've worked in an area where privacy is important, they often think that a privacy requirement would trump a requirement to provide documents as part of litigation, but it doesn't. Privacy legislation is actually subservient to the court rules, and you can't claim that something is private or confidential and therefore not provided.
Right.
Once you're within the process.
Yeah. Right. You've mentioned discovery during our discussions. What do you mean by discovery?
Discovery is a process which occurs within litigation, and the Australian legal system and other legal systems as well work on the basis that the court is trying to obtain the truth. And as a result, the general principle is that all of the relevant documents should be available to the court. So that means that once litigation commences, this is civil litigation, then you have to provide all of the relevant documents to the other side. Mm-hmm. And there have been some spectacular examples where terrible documents have had to be provided, particularly often internal emails. They are the quite extreme example. That's the one that you see all the time now.
Sure. So once these documents have been discovered and provided to the other side, are they fair game in terms of being available for anyone?
No, there's an implied undertaking that they're only able to be used for that litigation.
Okay.
So,
well, thank you, Fiona. Thank you for that information.
Thank you. Before I go, I'd just like to mention that this interview and this video are not legal advice to any particular person. Mm-hmm. If you're thinking about acting or not acting, you shouldn't do it based on this video. You should obtain your own advice.
Thank you.